law theory, and in terms of their background, in terms of their professional careers. They've been faced with lots of various issues and threats, and were always able to effectively respond to those threats. The topic that we're going to discuss today at our round table. Here comes Madam Paolo Severino. We're happy to see you, so I will cut on my introductory remarks. So these topics were formulated many times, including the round tables of our fora. The world is becoming more and more global. The threats that the humankind is faced with every year are new, although they are based on the same old reasons that are deeply entrenched in human nature, in the texture of the society, in competition, in imperfections of the society. However, the manifestations of those fundamental problems testify to new modification of threats emerge, and lawyers as an active professional community are forced to respond quite seriously. And of course a lot depends how this will, well, a lot depends on their response. The history of the 20th century and of course the history of preceding centuries gives us lots of examples where a threat that emerged for the society at large, for separate peoples or groups of people, were of a very dramatic nature indeed, and could lead to very serious catastrophes, and often ended in massive bloodshed and social upheavals. But the response to those threats was more or less effective at times, but what is more important for us lawyers is that this response was oftentimes quite doubtful from the point of view of the rule of law, from the point of view of justice, from the point of view of guaranteeing human rights. Among the fresh examples that come to mind, and those examples date back to the epoch where we have a universal recognition of human rights and security of human beings, where to a large extent discrete decisions were by and large cut down. For example, the gangsters in the United States in the 1930s, during the time of the global depression, of the Great Depression. But as we heard in Russia here, where American lawyers, American prosecutors found out that it is very difficult to accuse and sentence criminals if they comply with all the rules of procedure. So they were sentenced not for those grave crimes that they have committed, but for tax evasion, for example, or they were just killed in shootouts. Those shootouts were provoked in public places and they were just killed on the spot, and that was it. And to a large extent they were successful in counteracting this wave of gangster activities. A similar thing happened after the Second World War in the Soviet Union. We just had a huge triumphant victory over our enemies, but gangs emerged at the same time. Those people had just come from the front and that joined those gangs. And the Soviet Union also coped with this wave of banditism in some 5 to 7 years, but the price was extremely high. We had to introduce very strict punitive measures. Capital punishment was used by and large, not for the most grave, or not, and very often not for the gravest of crimes. And I heard those and I read those cases, and there are lots of questions that arise. Today we are also faced with lots of various threats such as extremism, terrorism, human trafficking, piracy, dissemination of very explosive information by the internet. All of this sets the same set of issues in front of us. And very often we have to question ourselves whether the means that we apply to attain our goals are justified. The killing of bin Laden, the Guantanamo prison, those problems that we used to have from time to time in North Caucasus, and those problems continue. Well, the objectives are always noble, but how do we attain those goals? What are the means at our disposal? Those are the questions that I would like to formulate as an initial food for thought in order to set the trend, the direction for our discussion. And one more example, that will be the last I will say. In 1971 in Texas, a person was born in Texas who was called Lance Armstrong. He became professional sportsman. He won the bicycle race, global world bicycle race. Then in 22 years he fell ill with cancer. Metastatic cancer. He was treated medically very successfully, and he returned to the sport, and for 7 years in a row he was the winner of Tour de France, the most difficult of all bicycle races. He was the example of fair play in sport, and last year the American anti-doping agency disqualified this sportsman for using doping and took back all his victories from him, and this name is now no longer in the history of world sports. And probably this decision was right from the point of law. But myself, as a former semi-professional athlete, I have a question. When organizers of various races make sportsmen work for 3 weeks, for 18 maybe hours per day. Their pulse rate is 120, and they have to go along very difficult mountainous stretches of legs of their race, and we cannot count that the first 100 athletes, to make sure that the first 100 athletes don't use doping in this situation is absolutely impossible. And very often we delay the discussion of very serious problems for an indefinite time, and we provoke the perseverance of this problem in a frozen state. And within this space that is not under discussion, this problem tends to evolve, this problem tends to exacerbate, and finally we are faced with the same problem, but which has become much, much graver. So this is what I wanted to say, and probably this will also set some sort of a direction for our discussion. I would like that to give the floor to Madam Paolo Severino. We are gentlemen, and the first should be the lady to take the floor. Not long ago, Madam Paolo Severino was Minister of Justice of Italy, and she, as a representative of Italian justice, is an expert in such issues as, for example, illegal migration, because Italy is in the forefront of combating the wave of migration coming to Europe, and since bike races are also very popular in Italian, and the doping scheme I referred to was also organized by an Italian. So, Madam Severino, what do you think about all this? Mr. Minister, dear colleagues, thank you very much for giving me an opportunity to speak at this forum. And of course, the topic that were covered by Mr. Minister and I'm thankful for him, are exceptionally important. And I will start talking about a country that is the first to meet illegal migrants coming to Europe. There are, of course, positive and negative examples. We use different measures, sometimes very stringent and severe measures, and to sort out those who migrate for evil purposes is very difficult for a country which is geographically located in such a way that it has to deal with immigrants on a daily basis. Of course, we are a country which becomes a barrier for immigration into other countries. Illegal immigration is also related to another problem which is also very important, particularly abduction of people, recruitment of terrorists. Therefore, in Europe, other countries also are confronted with illegal migration because not often our countermeasures turn out to be effective. The whole of Europe, all countries geographically belonging to Europe are forced to fight with illegal migration, and the topic of my today's presentation is exactly about this. It is quite in line with what Mr. Minister was saying in his introductory remarks. So what kind of measures should we undertake in order to counteract organized crime? The Italian language is extremely rich, and I use the word measure in two senses. On the one hand, measure means size, and on the other hand, measure means a tool that is used for this or that purpose. So the measure of measures is always to identify. It is very difficult to draw a line between these two meanings of the word. Our Mr. Minister was talking about aims and means. He said that it is difficult to identify adequate measures to attain this or that goal, while we must find measures in order to achieve our goals of counteracting terrorism. It is very difficult to identify just measures, and governments are often criticized because they do a lot or too little in order to counteract terrorism. They are criticized because they are doing too little, because they say that today the borders between countries can be easily infiltrated by terror agents or organized crime, and the governments are often accused of not controlling those processes properly. On the other hand, people say that governments do too little, but on the other hand, other people say that governments do too much. Namely, they take measures that are too stringent, too harsh, aiming to overcome international crime. Governments are accused of disproportionately stringent measures against organized crime and terrorism, which are in breach of fundamental human rights. In the circumstances that they call exceptional, the government authorities frequently disregard constitutional guarantees and fundamental human rights. There is abundant case law on this issue from international courts as well as from state courts at any latitude. Due process is often under scrutiny. In 2006, the Hamdan judgment, the U.S. Supreme Court ruled that military commission set up to try alleged terrorists were in breach of due process. Alongside the violations of due process, prolonged detention is also a matter of grave judicial concern. For example, indefinite detention of foreign terror suspects has been found to be in breach of human rights by the European Court in Strasbourg, most notably in 2004 case against the United Kingdom. The third example are extraordinary renditions. They have been deemed illegal by Italian courts at all levels, and Sweden was condemned by the United Nations Committee Against Torture in the 2006 Agiza decision. Of course, these two accusations contradict one another. Governments do either too much or too little. What does it mean, too much or too little? These two notions do overlap. And all this shows how difficult it is to identify an appropriate measure and effectively counteract organized crime. The measures should be in line with the goal, but the human rights should not be infringed upon. This is the first problem with measures and adequate or inadequate reaction. The type of intervention on the part of the states. In order to the government take appropriate measures, we should study the goals pursued by terrorists and organized crime, and after we have defined the goals of those criminals, we will be able then to find just and sufficient measures to combat this phenomenon. For example, international terrorism as such, no global terrorism, can be best described as an attempt to subvert the state system as a whole. So the goal is not to just undermine one national state, but all states taken together. And of course, stringent measures should be of a specific nature, but very often they are taken at the level of national state because the interests of national state are under threat here. Take insurgency, for example. Its aim often is to seize power within a given community, and it may destabilize the situation in a given country. So insurgents replace traditional elites with themselves, and global wars also lead to negative consequences for the international community and undermine the fundamentals of separate national states. The most important goal here, the goal of transnational crime, is to disrupt, to weaken the state. They're trying to make the state a structure to be that is easier to infiltrate or penetrate.
As for the global terrorism, it operates from the foreign mindset. When we discuss wars which are waged by certain states to counteract certain evils, the final purpose is not to gain power within the given state. The aim is to use the country's area as a certain floor to infest other countries and other states. And this chain may continue for a long distance, and the whole systems of states are disrupted. And this is the latest step or stage of violence in terms of its complexity. From the viewpoint of time, we more and more frequently are witness to such types of threats. As for the international organizations, they must make their own contribution to counteract global terrorism, global crime, and such combat may not be an aim for one country alone. It must be the common goal for all the countries taken together to prevent the destruction of the system called the state. To draw the bottom line, as soon as we have established the goals of the crime and criminal circles, if countries want to counteract criminal attempts to disrupt the countries, they must combine their efforts and pull together their efforts. If we start the discussion of the types of measures which we may put in place, the minister invited us to say how we in Italy made a decision to take measures against international terrorism, being the first one in this move against international organized crime, and Italy, of course, had to react. And we naturally decided, first of all, to take measures of proprietary nature. The more crime is organized, the broader its membership, the more financial resources it needs. Therefore, different types of crimes, such as terrorism, economic crimes, are interconnected. They make one major phenomenon, where terrorism, of course, gets food from organized crime through the trafficking of weapons and drugs. For example, take Mali, the country where terrorism has established a very important base. This is the country where arms trafficking and drugs trafficking have developed because nobody took care to put in place preventive measures as well as measures of the other types. And it is from such countries that capital flows, which is used to finance international terrorism. So if we look into the very essence of the challenge, if you want to combat a global scale phenomenon, if we are to combat organized crime and arms trafficking and drugs trafficking, since terrorism finds plentiful food in such sources, drawing huge financial resources from illegal proceeds. Therefore, we must curtail opportunities of getting gains from illegal arms trafficking and illegal drugs trafficking. Italy, which was the first country compelled to fight such a phenomenon as mafia, for example, there was a great judge, Falcone, the first judge to be killed by mafia, who found efficient measures to counteract mafia. He was teaching us how to combat organized crime by cutting the channels of funding and supplying mafia. We find these are proprietary, efficient monetary measures of combating mafia to make mafia starve. Therefore, if we decide to seize illegal property, illegally gained property, we see tremendous success stories. In other countries, we try to raise awareness of such measures, and we want to stress that these are very efficient, bringing good results. For example, in Central America, recently a conference was made under the auspices of the UN, and through the UN sources we tried to circulate the importance of such measures. Such measures as fighting the illegal arms trade and drugs trafficking. This is a system which, however, such a system may disrupt constitutional rights of citizens. In Italy, of course, we put a lot of stress on protecting human rights, and we established a system where an independent judge in the course of the proceedings must take into account, for example, all the just make a preliminary decision. He must just make his mind before starting the proceedings. The subject of a judge understanding the all the set of information is very important. For example, take a look at the Netherlands in Europe, as well as other European countries. They take preventive measures, enabling them to combat organized crime at the international scale. Just mostly by withdrawing and seizing financial sources, financial funds. Things that economic gains which are obtained through abduction of people and illegal arms trade are tremendous, and we in Europe are trying to disseminate this idea about opportunities available to us in our efforts to curtail the scale of criminal activities. And in Italy, in the interest of a country where no legal framework has been established yet for combating organized crime through such means, crime is flourishing. We call it the forum shopping, where mafia and crime is looking for countries where the best opportunities exist for them to obtain such funds, illegal funds. And whereas in countries like Italy, where preliminary measures have been made for curtailing and cutting down financial sources available for mafia, results obtained are quite positive. For example, in Europe, many countries naturally are trying to follow Italy's suit. Legislation must be harmonious in Europe. In such a way, we will unite our efforts, pull together our efforts, and we will be able to successfully fight horrendous crimes such as international crimes, global crime and terrorism. And I believe that fora of this type and meetings of this type are very important for all the countries to realize that only through harmonious and uniform measures can we win in a fight against such a broad phenomenon as global crime and global terrorism. Okay, I would like you now to thank Severina, and please put down a note about a question you want to ask. I would like to remind all the speakers that we must set aside some time for a free discussion, Q&A session. About 10 minutes will be enough for such session. In December last year, I was in London and decided to attend a rugby match. However, my driver, who made a mistake in putting down data into his navigator, brought me to a different stadium. So I missed my stadium. However, he brought me to a very important part of London. You will remember that about 2 years ago, broadly televised was a picture of burning houses on the violent streets, rioting on the streets. And there was a lot of questions which could best to the London police about how in such a rampart of law and order such things could be possible. Well, your country has long ago been acknowledged as one of the law enforcement leaders worldwide, and it has always had a special opinion about different things, including rulings of the European Court on Human Rights, including membership on different conventions, including European Convention on Human Rights, because membership in such a convention limits your opportunity to combat terrorism. So I would like now to give the floor to the Minister of Justice of the UK, Deputy of the Speaker of the House of Lords, Lord McNally.
Thank you very much, Chairman. As I reminded you yesterday when we met, I am not a lawyer. And neither am I a philosopher. When I fill in the profession on those notes that they hand you at airports, I just put politician. And it's not a profession that I'm ashamed of. But it's as a jobbing politician that I'm going to speak to you today. Professor Severino reminded us of the multiplicity of challenges that we face as citizens and as states, guaranteeing due process, protecting human rights, avoiding torture or illegal rendition, the challenge of terrorism and of organised crime. None of them new in terms of challenges, but perhaps in the 21st century and with modern communications, with new dangers to them. And I've worked in and around Whitehall and Westminster for 50 years now. I can remember when number 10 Downing Street, if you visited number 10 Downing Street, you could stand on the steps and have your photograph taken, and the Prime Minister might well walk out while you were doing it. There are gates at the bottom of 10 Downing Street now. When I first went to Parliament, you could walk straight in and stand in central lobby and watch the politicians go to and fro. Now you have to go through security checks, and there are armed guards stand at Parliament. And once I arrived at an international airport late, and they put me on a buggy and drove me out to the end of the runway and shoved steps up against the plane so that I could catch the plane that I was delayed for. I'd have to take at least 3 hours now to do that. So I know that we live in a very different and more dangerous world. What I do know is that, as you say, my country has a long continuity in its political development. In the 18th century, it was perceived that we had a separation of powers between our judiciary, executive and parliament. Montesquieu didn't get it quite right, but they were there, those elements. And what I would say is, in addressing some of the challenges that you were talking about, those elements have a very important part to play. If we're going to address that multiplicity of challenges, whilst retaining the essential freedoms that we are intent on protecting, then there is a need to protect the judiciary, even when judges make decisions that irritate the executive. Parliament has to keep a very strict eye on and have the powers to check and balance the powers of the executive. And the executive always has to act within that concept of the rule of law. And of course, there is also that fourth estate of a free press, which is essential to those checks and balances. And as you said, Chairman, there are also now international obligations in terms of the United Nations and the Council of Europe in terms of protecting human rights and standards of behaviour. We, in 2 years' time, will be celebrating the 800th anniversary of Magna Carta. And when Eleanor Roosevelt announced or launched the UN Declaration of Human Rights nearly 60 years ago, she described it as a Magna Carta for all mankind, and there was no need for simultaneous translation. People understood the concept of citizens' rights in relation to the state. And our great jurist, Lord Bingham, recently dead, pointed out that actually if you examine Magna Carta very carefully, it isn't quite the great declaration on human rights that people imagine. But what he did say is that the spirit of Magna Carta had gone down through the ages and influenced governments, individuals, in how they thought there should be the relation between the citizen and the state. And I think that really what we're talking about today, and the challenges that you've set us, is how we defend our citizens and protect our states from real and present dangers that are undoubtedly spelt out, and which all of us, or many of our states, have suffered from directly, without giving in to pressures on civil liberties and human rights, which actually make self-defeating the protections that we're trying to bring in. If you want 100% guarantee against some of the attacks that you're talking about, you'll end up with a society with none of the freedoms that you want to defend. And so really what I'm making a plea for is a plea for the politicians to be brave. In the mid-70s, I had the honour of working with the then British Prime Minister, Jim Callaghan. And I do recall we were once briefed by our security services about various things that they wanted to do and needed to do in what was then the threat from IRA terrorism. And after they'd left the room, Jim turned to me and said, always listen to what they say, but never suspend your own political judgment. And I think in all our societies, that is the challenge. Listen to the good advice about what's needed to protect our societies. Defence of the state, defence of the realm is one of the first responsibilities of government. But balance that against those parts of making us free societies that need to be protected in all circumstances. For me, I've been a Minister of Justice for 3 years. To me, the high point for me of my time in office was to go to Geneva as part of our universal periodic review of human rights and to answer questions from other states about how we were performing. And I saw that as a proper role for a minister. Last year in Brighton, we had the 47 members of the Council of Europe looking at how we can make the European Convention more accepted. And to me, again, it was inspirational to see those countries join together to common standards and common recognition of common values. And so it's in that respect, and as I say, as a jobbing politician, I say that the challenges that you've set out are real challenges, and any responsible politician has got to respond to them. But he's got to respond, he or she has got to respond to them within those contexts of those universal values. Thank you.
Thank you very much, Lord McNally. Professor Ogletree works at Harvard University. He was one of the teachers of President Obama. Unfortunately, Boston was also a victim for a terrorist attack not long ago, although we always thought of Boston as a very quiet and academic and very secure place. The people who instigated this terrorist attack to some extent were a natural extension of the American understanding of American dream in terms of career, where representatives of a different country, of a different people, are organically incorporated into this huge melting pot of cultures and becomes a part of a huge and successful state. Recommendations on how to put together an explosive device were taken by those brothers from the internet. Mr. Ogletree, do you think there are any limits, any restrictions on ways of providing full freedom to people in their activities and freedom of expression, and what those limits should be, if any? Please, you have the floor.
Thank you, Mr. Minister. First of all, let me thank you for inviting me to participate in this forum and to say a few words. I wanted to say three things. First, I'm not speaking on behalf of the United States government. I'm not speaking on behalf of my employer, Harvard Law School, or any other organization with which I may be associated. I'm speaking as a professor, in my experiences, as a lawyer, and more importantly, as a citizen of the United States of America. I want to address four things very quickly. The first is a historical examination of the United States. We are called a nation of immigrants because people from all over the world have arrived in New York and other places. And there, the Statute of Liberty is a welcoming statute for all people. And Imre Lazarus said many years ago a term about America: give me your sick, you're tired, you're poor, yearning to be free. And we've tried to embrace that. We have a constitution that is very broad and generous in its protection of the rights of individuals. We have three branches of government: the executive branch, which is the president and the White House; the legislative branch, which are Congress, both the House of Representatives and the Senate; and third, the judicial branch, which is our Supreme Court. And each of them operate independently, but are in a sense related in very significant ways. And so that's a little bit about the history of what we come from. As a result of that, the Constitution gave us the Bill of Rights and a set of amendments designed to change America as its population changed. Everyone came to the United States usually by ships. Some of us were in the higher sections of the ships, but the enslaved, like my descendants, were in the basement of the ships because they were brought to the United States as slaves. Notwithstanding that, we are a nation that believes in the rule of law and has been embraced in many significant ways. Let me talk about two incidents that I think that reflect this, and how this balance between, as we talk about goals and measures, is a very difficult one. And what I would argue is that we have to have a delicate balance, and that balance is between both security, to make sure that individuals and government is safe, and liberty, the right to speak out against the government, to address issues freely, and to, in a sense, be respected even if you have a different point of view. As I think about that, the two incidents that have changed a lot of our views about security happened in this century. The first happened on September 11th, 2001. As the minister mentioned, there was the attack in New York, in Washington, D.C., and in Pennsylvania that left more than 3,000 Americans and foreigners as well dead and many, many injured. Those were the attacks on the towers in New York, and the plane that crashed in Pennsylvania, and then the attack on the Pentagon in Washington, D.C. Despite those events, there still is a yearning for freedom and how important it is, and the idea that liberty shouldn't be sacrificed even in these tough times. That act in 2001 was not only damaging to thousands of people around the country and millions around the world, but I lost friends, people that I knew very well. And yet I respected the right of the government to both respond, but also to do so with the measured response as required. As the minister mentioned, just on April 15th of this year, 2013, there was a different attack in Massachusetts, in Boston. What's ironic is that both the September 11, 2001 event started in Boston, with planes taking off, many of them from the airport in Boston, and eventually being missiles that killed people in New York and Pennsylvania and Washington, D.C. And then April 15th, we were, in a sense, attacked by two individuals, and that led to the death of 3 people and very serious injuries of hundreds of people. I can tell you that the responses of people in the United States have been very different to these assaults. One is retribution, people wanting to respond and make everyone pay a debt for the attacks of 2001 and 2013. And others is a sense of justice, to make sure that there's a process that applies in 2013 that applied decades and centuries before. We shouldn't lose that. And speaking of the 2 young men who are, I think, a Chechnyan origins outside of Russia, one was the 26-year-old Tamerlan Sarneev, and the other was his 19-year-old brother, Dzhokhar Tsarnaev. And they were identified as being involved in the bombing on April 15th, 2013. One, the 26-year-old, was killed there, and I'll say a word about that in a minute. And the second, the 19-year-old, was hospitalized and is now going to face a series of charges. What is unique about it? It's no question that evidence has shown thus far without a trial that these individuals brought bombs to the location, set them off, and injured and killed a number of people. And yet, the essence of democracy and the essence of our system was that the 19-year-old was treated at a hospital by doctors without worrying about payment to make sure that his life was preserved. And that is the essence of democracy. The other, which people may not know, was actually buried in an American cemetery in the state of Virginia. Much protest, much objection, but the government's view was that this person deserved a burial and in the United States. And it was done over objection of the people who were incensed that we would treat, quote, foreigners in that way. By the same token, both of these brothers received many benefits from the United States. They were educated at our schools. They had jobs in our nation. One received full citizenship. The other had a green card that allowed him to move about. They worked for American companies. One received public assistance because of his indigency. And so there was a sense of being open to the role of immigrants that made a big difference. Now, what does it say for where we are now? It says that our Constitution and our Bill of Rights still are as strong in 2013 as they were decades ago. As example, let me move away from these two cases and talk about how I think it's worked. Some of you may recall that in 2000 we had a national election for president of the United States. And as a result of that, two people were in close combat to win that election. One was George W. Bush on behalf of the Republican Party, and the other was Al Gore on behalf of the Democratic Party. As the votes came down, it was a very close race, some declaring Gore the winner, some declaring Bush the winner, and they were still counting ballots in Florida. Our Supreme Court stepped in and stopped the counting. I objected to that. A lot of people objected to that, and I think we were equally divided as a nation. And yet we saw the Supreme Court, by ruling 5-4, that the votes should stop being counted and that the election should be upheld as the essence of the rule of law. And the court, even though I would disagree with it, maintained its integrity as a body that would make tough decisions, even in situations like that. All of these point to, and I'll end here, on the balance between protecting our liberty, our right to move and speak and participate in any activities, even those critical of government, and security, our expectation that our country will provide us with a sort of protection and support. The security has reached new limits. Not until after 9/11 do I, like every person, whether you're a citizen, an immigrant, or a visitor, has to go through an extensive search and before going to an airport to make sure that no one has weapons, no one creates danger to other passengers. And I have no objection to the idea of security so that everyone can fly freely or take a train freely or take a boat freely to move around. That's a sign of the restrictions based on this, but it's important. I think we're going to redouble those efforts of security, but I don't think they could be at the cost of liberty. We still have to not only admit and accept immigrants and visitors to the United States, we have to accept them gladly, and we have to at the same time prepare ourselves for the risk of threats both internally and externally. And I think in terms of the next steps, I agree with what Attorney General Eric Holder said a year ago when he came to this conference and spoke about the balance between our government and all governments. And I would say these things in conclusion. We are a smaller group of nations than ever before, in the sense that we have a collective vision and a collective interest in providing security worldwide. Number two, that we have to respect the right that terrorism is with us and is not going to disappear at any time. And number three, that terrorism can be by an individual, by a group, by a nation, and it can come in all sorts of forms, not just simply bomb, but through the poisoning of the air, or through water, or many other ways as well. And I think we have to both understand that and prepare for that. And finally, I would say this, say a word about President Obama before I end. He was a student of mine at Harvard Law School, and so was his wife, Michelle Obama. What's remarkable about President Obama, he reflects what we all are about in the sense that his father is from Kenya, an African. His mother is from Kansas, a white woman from a state in the United States. And collectively, they represent what we're trying to achieve. That is, that we are one nation and we are indivisible. We're under the views of authority of God, and we believe in liberty and justice for all. And I think that even though we both will look at the incident of April 15th as a tragic one, at the same time, it cannot and should not cause us to close our doors and not be receptive to the idea that we will remain a nation of immigrants, even as the challenges of April 15th make it harder to do. We will maintain that sense of integrity and justice for all. Thank you.
Большое спасибо.
Thank you very much, Mr. Ogletree. Of course, your position was very clearly stated. It was very impressive. The next speaker at our roundtable is Akira Kawamura, the 22nd President of International Bar Association, a very experienced lawyer who practiced in many areas in the field of guaranteeing the rights of the accused. He dealt with many international terrorism cases. He has a unique set of experience, which is extremely important, and his vision is very important for us. Apart from that, Mr. Kawamura, you are a philosopher. I feel that, and your country is an example of a philosophical attitude towards life, which brings practical results now and not in the distant future. I have a philosophical question for you, which we haven't touched upon yet in our discussion. Don't you think that, on the one hand, if we put guarantees of rights and freedoms of people on top, and at the same time we continue to strengthen the cult of consumption, we provoke people to take doping, to try to be more successful irrespective of their own talents and capabilities, irrespective of their responsibility, irrespective of the rights of other people and the security of other people. And continuing to strengthen our own countries, ensuring their priority in world economy, in political culture, in world politics, which is quite understandable. Don't we, in this way, provoke weaker countries to undertake inappropriate actions that they are bound to commit sooner or later? Thank you.
Well, thank you very much, Mr. Karavanov. Evidently, you overestimate my ability. The question is difficult, but I think I may answer to some extent in my speech prepared for today's topic. As you may recall, my own country, Japan, was just a couple of years ago once a potential and serious threat to the safety of the neighboring countries, including Russia and the United States. It was the Fukushima nuclear plant failure that originated from the devastating earthquake of March 11 in 2011. I thank you all very much for the huge amount of the sympathy and help that were generously given to our people for the casualties and the loss suffered by them. We were fortunate because no one in the world has attempted to take any counter action against the threat of the nuclear activities leakage and emission through the air and water. We highly regard the patience and intelligence of the peoples of the neighboring countries, including Russia, maintained throughout the time of Fukushima nuclear power plant disaster. Although Japan has reasonably well recovered nowadays from the aftermath, the aggregate amount of the loss, damages, and the cost caused by the nuclear power plant failure is still accumulating and could end up being an astronomical figure. No one knows how much at this stage. The number of residents who were ordered to evacuate their homes because of their proximities to the damaged plants was approximately 500,000, among which 100,000 are not yet permitted to return to their homes as of today. It was a big threat to Japan, not just to the overseas countries. Even after the Fukushima disaster, Japan continued to have stressful threats to the peace and well-being of the people. Those threats include a very real threat of nuclear war by one neighboring country. The others are the sovereign right disputes over remote islands on the Japan Sea. These territorial issues may likely lead to the exercise of military power if those issues are not politically or diplomatically settled in a timely way. The most likely counteraction that may be taken on the Japanese side could be to strengthen dramatically the nation's military power by abolishing the prohibition of use of military power provided by the Constitution of Japan. This is an idea that has been actually introduced to the political agenda by the present government led by Mr. Abe. This is the real issue for Japan today. How to counteract against the threat of military conflicts over those remote yet politically important islands. This is the first time in the 67 years of history of the Constitution of Japan that such an amendment, serious amendment to the Constitution is being considered. The Japanese voters would decide very soon the right balance between those political goals and the measures that may need to be taken to achieve those goals. As you should be aware, the General Assembly of the United Nations adopted the resolution on the rule of law on September 24, 2012, last year. The adoption of this resolution is the outcome of the strong leadership exercised by His Excellency Ban Ki-moon, the Secretary General of the United Nations. I would like to remind you that the same point as to the rule of law was made by His Excellency Dmitry Medvedev, the Russian Prime Minister, in his keynote speech given to this forum last year. I was impressed, and with the permission, I had the honor to introduce his remarks very openly and broadly to the Japanese legal community, which was very well accepted. I must agree with Mr. Medvedev in full as to the issue of the rule of law. The balance between goals and measures may only be weighed by the rule of law, nothing else, not the politics. The nuclear plant's accident may not be absolutely prevented only by the rule of law, but any of the territorial disputes must be exclusively solved by the rule of law through the judicial system, if not by the mutually friendly settled. My longtime friend, the former United Nations Legal Counsel, Mr. Hans Koller of Sweden, wrote just last week, for a Swedish newspaper, an article entitled as "The Human Rights Under Threat After 9.11. He stated that one must not engage in torture or must not believe that one can make war on terrorism. Torture and terrorism are crimes, that the other crimes must be fought through the law enforcement mechanisms. I was fully convinced by his article and believe that these present-day threats that may threaten the peace and well-being of the people must be resolved by the rule of law principles. The rule of law in the international context should not remain just the principle, but should be effectively enforced by the international law enforcement bodies like the United Nations, the International Criminal Court. They must be fully functioned as such, and I would like to say that international lawyers who may run such international mechanisms must be educated, grown up, and must be the large power. I was the president of the IBA for the past 2 years. The IBA was formed in the year the United Nations was founded and had been closely working together with the United Nations on many current issues, including the human rights, international enforcement of law like the International Criminal Tribunal for the former Yugoslavia, and interventions relating to the cases at ICC. Myself attended for observation the court trial of Laurent Gbagbo, the ex-president of Côte d'Ivoire. IBA Human Rights Institute is making interventions against the human rights abuse for the minority people in Myanmar, and myself called on the United Nations Human Rights Council to urge them to make a formal inquiries into the problems. Thus, I believe that IBA is the strong and determined NGO, very much instrumental to the rule of law enforcement mechanism in the world. I think the IBA must help promote rule of law and must educate, grow many international lawyers who may support such law enforcement activities. Well, Mr. Kurbanov, did I respond to your question?
В соответствии с традицией, японской традицией, это было очень...
Well, in line with the Japanese tradition, well, maybe it was a rather philosophical answer, starting from very far away. But Mr. Nakamura, thank you very much for your presentation. Thank you. Maybe I will understand what you meant sometime after. And the last speaker is Mr. Niilo Jaskinen, Advocate General of the European Court of Justice. He is the last presenter.
It's an honor and a pleasure for me to participate in this seminar. Unfortunately, President Skouris of the European Court of Justice couldn't attend, but he sends his greetings to you, Mr. Minister, and all the participants of this important legal forum. I've decided to speak about the role of the rule of law principle in the European Union. European Union is exceptional among international organizations that it's based on the rule of law principle. From the establishment of the European Community of Coal and Steel in 1952, the European integration has been based on the idea of a community of law. This means an organization which is based on common rules and principles with effect outside the circle, outside the narrow circle of executive, and following the pattern of constitutionalism, not of international diplomacy. Different legal cultures have different traditions and interpretations of the rule of law. It's even quite difficult to translate this notion in various languages. German Rechtsstaat emphasizes judicial protection of the subjective rights of individuals. French approach is more concentrated on the control of legality of administration, the idea which was actually created by the French Conseil d'État, the idea of separate administrative courts controlling administration. In the Anglo-Saxon legal culture, rule of law means primarily due process or effective judicial protection. This being translated into access to courts, effective remedies, and fair trial. In the Nordic tradition, the idea of rule of law was expressed by one eminent Finnish lawyer as the idea of democratic progress on the fundament of legality. This emphasizes such values as transparency, good administration, wide opportunities of democratic civic participation, and judicial protection of individuals that is easily accessible, cheap, prompt, and effective. In a multinational legal community, such as the European Union, the rule of law principle must reflect these different traditions and combine their approaches. As such, the idea or the importance of rule of law as the founding principle of European Community law was recognized by the Court of Justice already in the 1950s. However, I take the opportunity to tell you that on Monday this week, the Court of Justice organized an international seminar to commemorate the 50th anniversary of very important Fangen and Laws judgment in 1962. In that judgment, the Court of Justice found that European Union law creates rights to individuals, direct rights which they can invoke before national courts, which, if necessary, refer the case to the European Court for a preliminary ruling. And this has put the individual and national courts at the center of European integration. Later, different aspects of rule of law have been consolidated in the case law of the Court of Justice of the Union and also included in the treaties among the fundamental values of the European Union. In the European Union law, rule of law principle comprises three main aspects. These are legality, recognition of the rights of individuals, and effective judicial protection. The principle of legality means that the action of the European Union institutions and the member states, when they act within the competence or within the sphere of European law, must be based on adequate legal competence and follow the procedures which are prescribed by law. The recognition of the rights of individuals means that economic integration and other cooperation within the European Union follows legal rules and principles that create effective rights to individuals, companies and natural persons who are the driving force of integration. The basic principle is that these rights must enjoy equal protection everywhere in the Union. These rights concern especially exercise of economic freedoms under EU law, but also and increasingly rights included in the citizens of the European Union and fundamental rights protected by the EU Charter of Fundamental Rights, which became legally binding in 2009 when the Lisbon Treaty entered into force. Third cornerstone, effective judicial protection, requires that there is a complete system of effective remedies protecting EU law-based rights. Moreover, the judicial protection must fulfill the requirements of fair trial as specified under the European Convention on Human Rights and the EU Charter of Fundamental Rights. Here, control is exercised by the national courts in cooperation with the EU Court. EU law has developed as law of economic integration. Therefore, the rule of law principle has been especially important as a guarantee of effective exercise of economic rights of companies and workers. During the last 15 years, EU law has increasingly touched non-economic fields such as family law, criminal law, asylum and immigration, or foreign policy. This has created new challenges to the rule of law principle. I'll mention three important judgments which show how this principle, rule of law, acts in these new eras. The Cardiff judgment of the Court of Justice of 2008 declared that the European Union Council regulation implementing United Nations Security Council decisions on list of persons with alleged contacts to terrorism are subject to judicial control by the EU Court. The fundamental principle of rights of defense and effective judicial protection is safeguarded even in a situation where you have cooperation under international law. Another judgment, recent NS case from 2012, relates to question of asylum. As you perhaps know, in the European Union we have so-called Dublin system, which means that asylum seekers' applications are examined by the member state where they have entered the Union. So if somebody enters the Union in Lithuania from Belarus and then asks for asylum in Great Britain, he is returned to Lithuania and Lithuania is responsible. But there are well-known problems of the conditions of asylum seekers in certain member states, and more particularly Greece. For this reason, in NS case, the Court of Justice declared that member states cannot transfer asylum seekers to a member state if it cannot be unaware that systemic deficiencies in the asylum procedure and in the reception conditions of asylum seekers in that member state amount to substantial grounds for believing that the asylum seeker would face a real risk of being subject to inhuman and degrading treatment. So the most basic fundamental rights override the common system of asylum policy in the European Union. Third case, also from last year, is Commission against Hungary. There the European Court found that the Hungarian legislation, which lowered the compulsory retirement age of judges to 62 years, with the result that the majority of the Hungarian judges would have retired, it was considered disproportionate and as such against European law. These examples show that the Court of Justice vigorously controls both the European Union institutions and the Member States in order to safeguard the respect of rule of law. Mr. Minister, now perhaps I speak more as a former Finnish Justice of the Supreme Administrative Court and in personal capacity about this question of exceptional threats. In 1920s, a German constitutionalist lawyer and legal philosopher Carl Schmitt said that sovereign is the one who decides over exceptions. And he pleaded for unlimited government and was actually the legal philosopher of Nazi regime in Germany. And the question that we must ask, is it so that unlimited government is stronger than limited government? Is a country which abandons rule of law stronger than a country which follows rule of law? And there I think that we could reflect this on the basis of the history of Russia. As you remember, during the 19th century, international terrorism was a problem. Several heads of states and other important persons, President Mackenzie, Empress Elizabeth of Austria, etc., they were killed by anarchists and other terrorists. And one victim of terrorism was, of course, Emperor Alexander II of Russia. Alexander II not only liberated serfs, but he also tried to introduce the idea of rule of law to Russian society by judicial reform, trial by jury, etc. His son, Alexander III, as a reaction to the assassination of his father, declared state of emergency, which continued till the Russian Revolution. And the question which we can now ask, did the Imperial Russia become stronger because of the state of exception, or would it have been stronger if the line of Alexander II, consolidation of rule of law, would have been followed? It also has to be emphasized that rule of law principle does not mean weak government. There are exceptional situations which might require emergency powers. The point of rule of law is, of course, that you have to have clear procedures and guarantees for individuals, and also that there are certain most fundamental human rights which cannot be sacrificed, especially right to life and right to freedom from degrading and inhuman treatment, and especially torture. You know, Mr. Minister, that the border between Russia and Finland is the longest border, external border of the European Union. And it's a border without any problems of illegal immigration, no major problems of international criminality. And why it's so? Because both parties have good administration, clear principles of rule of law, which they follow, and good cooperation. And that's it. That's an example that also threats which are difficult can be managed by in respect of rule of law principle. Thank you.
Thank you very much, Mr. Yaskinin. We have about 20 minutes for questions and answers, for a free discussion. Those who would like to ask a question, please formulate them as clearly and concisely as you can and address those questions to specific panelists. And those who would like to make a comment, please take not more than 2 minutes. The first to ask will be Mr. Slatkov, who applied several years ago, I think. You can do it from your seat. Dear colleagues, I would like to say the following in connection with our debate here. In languages of various peoples there is a set phrase, fight for life, a matter of life and death. When we think that we are strong, we can afford commensurate responses, but when we don't have this overpowering supremacy in force, then the question is about life or death. Then the situation is different. And when Stalin in 1942 signed an order, not a step back for soldiers, which is in total contradiction to humanistic values. In our today's virtual society, these problems get one more dimensions. In order to justify our freedom in the use of any means, well, the threat may be exaggerated, and the opposing party may be demonized. Hitler is Satan himself in the memories of most people, as Roman authors wrote about Ganimel. The hell came upon the face of earth. Maybe Bin Laden, Saddam Hussein, Gaddafi, Assad, I don't know. And here a question arises. Various threats or actions by people become threats not by themselves. They become threats only in relation to what we protect. What kind of values, what kind of sacred things are we trying to protect? And I'm not sure that in the world that we are accustomed to using civilized, we have complete consensus on that front. Very often the same words may signify different things. While people agree on words, they may disagree on what is behind them. Another question. To what extent we ourselves change in the light of our own ideas, using radical measures of this or that nature? To what extent do we lose our freedom if we use an effective measure to protect freedom? Do we have any certain borderline here, which, if crossed, will be very difficult to turn back? Any other questions or comments? Thank you. Unfortunately, the microphone is not switched on. Oh, here it is. Ekaterina Igorova, Permanent Secretary of the Federal Migration Service in Russia. Question to Lord McNally. All countries recognize that illegal migration is a threat. In Russia, we also we adopt laws. Now they are in the parliament, and we hope that very soon our initiatives on counteracting illegal migration will be adopted as law. And of course we monitor the policies of European countries in this respect. the last speech by Her Majesty the Queen contained a number of statements that show that not only legal migration, but in principle migration may be considered as a challenge. The Queen was in particular saying that migrants should not receive social benefits. And my question is about the following. Well, am I right in understanding that migration itself is considered to be a threat? Is my understanding correct? This is my first question. And my second question is, to what extent this reflects the public attitude in the United Kingdom? Thank you.
I think it'd be unfair to blame these statements on the Queen when she's reading the speech in Parliament. She's reading the government's policy. Is migration itself a threat? No, of course not. My name is McNally. It's an Irish name. It's 150 years since my great-grandparents left Ireland to go to Liverpool. And a lot of the history of the United Kingdom is a history of inward migration that has enriched our society, enriched our country, and this continues to be so. But like every other modern state, we have to make sure that the process of migration is controlled in a way that is fair both to those who are migrating and to the communities that have to accept them. And that's really what we're addressing. We are in a difficult position. The English language becomes an attraction. The fact that we have got a very well-established welfare state is an attraction. So getting the balance right is the challenge that we have. But the attitude towards migrants and migration in the United Kingdom has been as it has been for hundreds of years. They come, they become part of our society, they enrich our society, and if we get the balance right, that will continue to be so.
Thank you very much. Now we know the roots of Mr. McNally, and we know that next time we'll choose the right venue in St. Petersburg. We have a couple of very good Irish pubs in the city, so we might have a much livelier discussion there next time. Any more questions or comments? I'm Denis Puchkov from Rekatynburg. I have a question to Madam Paola. You chose the topic of organized crime from the point of view of undermining the government. How shall the international community and how can we understand or identify whether where we are dealing with international crime that undermine the government and should counteract it, and where we are dealing with simply freedom? I will give an example of different interpretations of facts. Today in Syria, for example, which leads to huge consequences. Well, as the majority of Europeans, I believe in the supremacy of law and in the sovereignty of states. But when the sovereignty becomes a stronghold that becomes a barrier, in fact, this barrier should be removed, because we need to look into one another's eyes and join forces in the struggle for what we all can define as organized crime and terrorism. I was trying to make this difference between the use of violence and terrorism. Terrorism is not war as such. Terrorism is not always obvious. Terrorism and terrorists use measures, they use force in a clandestine manner. Therefore, it is easier for terrorists to cross borders, to infiltrate borders illegally. In what refers to the difference between sovereignty and terrorism, well, this is a thought out issue. The use of disproportionate military force, the use of capitals for money laundering purposes, and the most important thing, international and internal jurisdiction may draw a border between legal and illegal acts. We have international courts that play a very important role, and they have to tell the use of state sovereignty from the abuse of state sovereignty. And we should also try to see what is legal and what is not. Thank you very much. So the unofficial prize for the best speaker judge was received by Justice Wolf. So you have about 3 minutes to summarize our today's discussion.
Surprise indeed. Thank you, Mr. Minister. I actually had a question, and I would like to put the question in perspective based on my experience as a judge in the United States. And the question is, to what degree in each of your countries are your governments and your people wrestling with, debating with, how much transparency can now be permitted and encouraged from government in this time of terror? The perspective from which I ask this question is the following. I think that in every country, when there is a well-founded perception of a threat, there's the sense that the ends may justify the means. If you were to Google me, you'd probably find that as a judge in my country, I am known as the judge who in the late 1990s conducted 9 months of hearings that exposed great misconduct and corruption in our Federal Bureau of Investigation. It was investigating the very dangerous Italian mafia, La Cosa Nostra. It needed informants. It employed notorious murderers to do that. And it successfully developed cases against La Cosa Nostra. But what I discerned and discovered was that in the process, the Federal Bureau of Investigation was protecting its informants in extraordinary ways, including by telling them about people informing on them who then were disappeared or were murdered. And as a result of that, the FBI agent in charge of this matter served 10 years for attempting to obstruct my hearings, and now is serving 40 years for conspiracy to commit murder. And the informant, who the FBI tipped off so he could be a fugitive for my case, has recently been captured and is facing charges of 19 years, charges of committing 19 murders while an informant against La Cosa Nostra. I began my lengthy decision in that case by quoting Lord Acton, who said, "Everything secret degenerates, even the administration of justice." And I think now, from what has been said, as Lord McNally says, we're challenged to try to strike the balance between liberty and security. It is political figures who ultimately must make those decisions. But I would like to ask if you could briefly say, in each of your countries, are you wrestling with the issue of how much the people can and should know, and is it as much as they traditionally have been permitted to know, so they can participate in an informed way in a debate that will inform the decisions of elected and appointed officials?
Ну что ж, начнем по порядку.
Okay, Mr. Ogletree, 100 words.
I think that what Judge Wolf points out is very real, and in fact, in the United States, we have embraced a view that people have the right to know who is threats to the United States and how we should respond to it. The one thing that we haven't talked about that's different in the United States than in many countries is that we have, as I said, the executive, legislative, and judicial branch, but there's a fourth branch that's not in the Constitution as a branch, but plays a big role. That's the press. And the press tells us everything, whether we like to hear it or not, about what is going on. They want to find out who's involved in organized crime. They have provided information that have been very significant in investigating those cases. They don't always testify, but they have been extremely helpful in bringing to our attention evidence of underground crime when government didn't do it, when organizations didn't do it. So I embrace the idea that we should have an open, full, and frank discussion about this. But I also believe, and I think Judge Wolf supports this, that even those who are charged with crimes, and I'm a former defense lawyer, have the same rights in a trial, the rights to a lawyer, the rights to the freedom against being interrogated without being warned of their rights to not speak, the rights to a jury that's not biased, the rights to a decision that can be reviewed by courts to make sure that there's no illegality. So the system has all these protections. Even if we're going after what has been described as bad people, they still, in my view, have the fundamental rights of our Constitution, and I hope that that will be sustained in other countries as well.
Большое спасибо. Господин Яс.
Thank you very much, Mr. Jaskinen.
From the perspective of European Union law and from the national Finnish law, we should distinguish between three different situations. The question is first the transparency towards the public in general. Second, transparency towards people who are affected by a certain governmental measure. And the third question is the transparency of trials, which you might have. As to the first question, I think both in European law and in Finnish law we have the general principle of transparency, but public security is one justification for limiting transparency. Then as to the question of parties, that's more difficult because there, of course, you have the right of defense that you should know if you are put under some constraints by administration, that why you are put so. But then the problem is that if you, in the terror context, some of the information is confidential, and it's confidential for the protection of the rights of others. For example, you might have information from third countries, and etc. And that's, in principle, denial of access, I guess, is accepted both by European law and by Finnish law, but then there are limits. The Cardi case showed it very clearly. These United Nations Security Council resolutions, which meant that diplomats in New York put hundreds of thousands of people on lists, perhaps with same names, and you might end up in a complete legal limbo. You are not allowed to take money from your own bank account. There has to be some kind of remedy, even though it has to be admitted that there is discretion for the authorities. And how large this margin is, it's actually pending in a case in the Court of Justice of the European Union. Then the third question, which is, I've understood, highly debated in the United Kingdom under the heading of secret trials, that's perhaps the most difficult one, because there you have the issue that you have somebody is really in criminal or administrative proceedings and he doesn't have access to evidence or access to file. And there I simply can say that in my recollection, the European Court of Human Rights has accepted that there might be very exceptional situations where this access to file by a party to proceedings can be limited, but of course that really has to be exceptional. The final point is, of course, that we have to look at these problems at the short perspective and long perspective. At short perspective, it might be justified to limit, but always when you have these kind of limitations, it creates, in a way, a rotten apple in your back. One part of administration is outside the normal control, and therefore, even if you accept something exceptional, you have to take care that it doesn't become a generalized system where ends justify means.
Спасибо, господин Лескинин. К вопросу четвертой власти мне только что сказали.
As for the question of the fourth power, I think Mr. McNally and has been waited for the last 20 minutes. Well, we're going to give you just 2 minutes because journalists are waiting there.
Very quickly, the closed material proceedings that were referred to is really the one example where we had a great national and parliamentary debate in Britain. And the agreement we reached at the end is, yes, there is certain information which for national security has to be protected, but those exceptional circumstances are in the hands of a judge in making that decision. And I think we've got the balance right there. Otherwise, I've spent a political lifetime believing that both freedom of information and transparency are benefits to good governance. And I think it was one of your great judges who said sunlight is the best disinfectant, and I agree.
Большое спасибо. Уважаемые господа, наверное, вы должны пойти на пресс-конференцию.
Well, gentlemen, I believe it's time for you to leave for the press conference because the journalists are waiting, the media are waiting, and, well... Okay. Very quickly. Very briefly, because, well, practically with everything which has been said by my colleagues, I am in complete agreement. The problem is not only transparency, the problem is in combining transparency and confidentiality, because in some issues, confidentiality must prevail. There are issues on top of that of the state secret, there are secrets of investigation, and there is closed information because it pertains to securing, safeguarding the state interest. And it's very hard to find the correct combination among all these intricate factors. You tend to call the media the fourth power. I would call it the first power. That is the power of the people who are free to inform the population, and each branch of the state power must be responsible for its activities and information which it disseminates. Therefore, maybe there is a need for making certain decisions of the ideological nature. They must be rather stringent to make journalists observe this balance between transparency and confidentiality.
Organized crime, Yakuza, and they are very strong, but they are presently specifically regulated by a special law under which any one of the group does anything, they will be almost immediately arrested. And so that function, that works relatively well. But nonetheless, this strong group of Yakuza gangsters still keep their strengths. And so, in a sense, we are peacefully coexisting with that organized crime. And so the transparency is never been seriously questioned. The judges who decide the organized crime has almost never been assaulted, attacked, or damaged by those professional defendants. And so relatively peaceful. And that is the Japanese. Perhaps the Japanese philosophy you mentioned may help, may be helping the situation.
Большое спасибо.
Thank you very much, ladies and gentlemen. I would like to summarize and draw a very brief dotted bottom line for this polemics, because the issues which we raised for the discussion evidently may not be resolved during, say, the next dozens or hundreds of hours. But we decided specifically to make an agenda of these issues because, as we say, the quality of the forum discussion is the principal result. I mean, the specific issues of law enforcement where we can may find specific answers to definite questions during the roundtable polemics. Thus, in some categories of discussion, we believe the important result would be even the fact that we ask these questions and formulate these issues, because it's an open secret that we politicians and legal professionals being involved in the everyday round of everyday issues have no time for formulating issues for the longer term of in the global context, which is the wrong thing to do, I believe, or maybe just a bad side aspect of our activities. Thus, defining new boundaries for our discussion, which we want to develop during the next, say, couple of years, would be very important for us, the forum organizers. So we did not intend to cut the answers in stone, which we would have to follow. But since we have started the discussion of such issues, is an important result in itself. And we've been doing this for like 2 years. And today we repeatedly said that one of the key issues today is the balance between freedom and security. Freedom and limitations, restrictions for the sake of freedom and security. Thus, there is a more global aspect of this balance, is the relationship between controls and trust. And I don't know if I will answer the question asked by Mr. Wolf, if I say that maybe in my maybe erroneous opinion, my personal opinion, in Russia today, this balance has always been has tended to shift toward more controls. And in those cases, when Russia neglected these controls, Russia lived through horrendous calamities, disasters. And in those cases, when this balance tended to move toward more trust, Russia lived through most incredible and just most incredible successes and rapid development periods. Another question which I would like you to think about, and next time in this audience and another audience, is this is the question which I would like you to follow. Thank you.